Okay, great stuff. We will get started. There's still some people joining, but we will get cracking so that we can get through everything today. Even sunny in Leicester, there we go. The perfect way to kick us off. So we're really pleased that you could join us. We're going to get started right away. James and I are both going to be presenting this morning. Laura's not with us, unfortunately, but says hi to all the clients and contacts that have joined us. She'll be back next webinar. For those that don't know who we are and maybe you're joining us for the first time, I'm Nick and I head the employment team at Actons, and Actons are based out of Nottingham. We have one office and we work across the UK with a variety of clients ranging from startups and SMEs through to some household names that you'll have heard of, some of which are on that slide. We're pretty active on LinkedIn. So there'll be some QR codes both on my slide there and more importantly with the rest of the team. And if you open your camera on your smartphone and scan that QR code, you can connect with us on LinkedIn, or obviously use the old-fashioned way of just typing our name in. It is a busy time in terms of updates at the minute. Most of you will not have missed the fact that there's new legislation coming in the form of the Employment Rights Bill. And we are sharing pretty regular updates both via LinkedIn, because that's the easiest way of getting them out quickly, but also our mailing list as well, with fairly regular updates. So it's a good time to be connected, I think, in terms of keeping track of lots of the stuff that's going on. Many people on the call we're working with already, and it's great to share our kind of knowledge and cover these topics. But obviously part of it is that we'd really like to work with you, and many of you we are working with. But if you like what you see, do get in touch, and we'd love to help you with this kind of issue and many other things that we cover. And there'll be a follow-up email with some of the detail of the stuff that's on that slide after the session. And one of the other fun things that we like to highlight, and I particularly enjoy being involved with, is a podcast that we host called the HRD Talks. And the latest episode came out only, I think, a week or so ago with Jan at Marston's. Really great episode. She's very, very open, actually, and very kind of vulnerable about her own story, but also shares some really great insights into how she sees the world of work at the minute, particularly focusing on leadership and the importance of sort of authentic leaders and leaders leading through change. So I would really recommend that episode to you, and obviously check out some of the other guests that we've had too. So that's the kind of intro section. We will use the chat as we go, and Matt's very kindly put a link to the podcast in the chat. There'll be various things that will pop up there, so it's worth having that available for you, because we'll talk about certain things. There'll be some links to some other webinars that we've done, and various other resources. But I think also as we go, because James and I are both presenting, we're actually really happy for you to pop questions into the chat, and we'll try and answer them as we go through. One, to keep it interactive, and two, so although we will have Q&A at the end, and we can pick things up as we go, and as you remember, if you have a question on any of the things that we're talking about. So feel free to utilize that, and we will get started. So as I talked about, we're going to look at the starting point for all of this. So the Employment Rights Bill is coming. It's actually, I think, having its third reading, I think, this week and next in Parliament, and that's setting the scene, I suppose, for lots of the things that we'll have to consider as employers, as HR people, moving forward. So we're just going to very briefly look at the most relevant part of that for today's session, and kind of update you on what's coming in case you've missed that, or you could do with a refresher. We're then going to look at hiring smarter, and we're going to look at managing better, and we're going to unpack that in a bit more detail as we go through. But that's the rough format. As I say, as we go, feel free to pop any questions that you have in the chat. So our starting point, October last year, we got landed with quite a big piece of legislation. So the Employment Rights Bill. And we also had the next steps document, which is on the slide there, with a lady hanging off the side of a building or something along those lines. If you're particularly interested in getting up to speed, if you're not up to speed already, I would recommend the next steps document rather than trying to dig into the bill. You really have to be very enthusiastic about understanding the detail to actually read the bill, because it's not easy to read is the headline. It refers back to previous legislation. It suggests replacing certain words in other legislation and taking them out, and all sorts of complicated things which we've had to navigate. But the next steps document gives a bit more of a headline and more accessible view on that. And obviously there are lots and lots of updates, including updates that we've done out there, which share detail on what's coming. But as I say, this was the government's plan, released in a bit of a hurry, I think it would be fair to say, to reform employment law. And I think they're certainly heralding it as the biggest change to employment law in a decade, if not more. And I think it will be. There's some pretty fundamental stuff in there. We will pop a link, probably when James is talking, I'll dig the link out to a webinar that we did not long ago, which gives a sort of headline view on lots of the changes that are coming in the bill. So you can get a better flavour for that if you've missed it. But it's essentially improving workers' rights. It's designed to modernise employment law and the framework to meet the modern world, is the way that the government are framing it. One of the key elements of the bill, and probably the most significant, although I think there are various others that people maybe are underestimating in terms of the significance, but the key one, and certainly key for today's topic, is the introduction of day one rights for unfair dismissal. So at the minute, for most unfair dismissal claims, there are a few exceptions, but most claims people have to have 2 years service with the employer to be able to bring that claim. And what this proposal is proposing is that the employee will have unfair dismissal protection from day one, as opposed to needing to have worked for 2 years. And that principle will apply, but it will be subject to a new concept of something called the initial period of employment, or shortened quite regularly now to IPE. During that period of time, it's likely, and I'm talking quite high level here because we still, even now, don't have stacks of detail on this, but it's likely to involve a different, what's been described as a light touch dismissal procedure during that initial period of employment. So there'll be a process and procedure that you need to follow after that initial period of employment, which is likely to be a bit more rigorous, a bit more onerous. And during the IPE, there'll be a lighter touch process. Now, we don't really know what the difference will be yet, and even with some of the amendments that have been made to the bill since it came out last October, there's not a huge amount of detail on that. One thing that they have clarified is that it won't be possible to bring an unfair dismissal claim prior to having started work, so day one, with the employer. In terms of that initial period of employment, it sounds a bit like a probationary period, but it's not quite the same. And I think it's going to be an interesting sort of interaction between contractual probation periods that people may already have in their employment contracts, and this new concept of initial period of employment. Part of the key detail that we're still missing is how long that initial period of employment will last for, and the government preference for a while, I think, and I think it was referenced fairly recently, is that may last for a period of 9 months. So that's kind of best guess at the minute. The other implication of that initial period of employment will be that it looks likely that it will be subject to a different compensation regime. So if someone successfully shows that they were unfairly dismissed during the IPE, the compensation regime looks like it will be different compared to a kind of normal unfair dismissal after the IPE has been completed. But again, we don't know what that will look like exactly yet. All that said, obviously one of the things that our clients are asking us fairly regularly is, okay, we know that that's coming now, what should we do? And I think one of the things we'd suggest is focusing on the topics that we're going to focus on today. And that's why we're doing this little introductory bit to the section on the bill, and why we'll talk about the things that we're going to talk about today. It's also, I think, important to think about looking at a review of your contracts and your probation periods. Are you using them already? Might it be worth introducing them if you don't have them? As I say, it could be interesting to see how that will interact with the IPE, and certainly supporting managers managing employees who are in a probation period or having started in a new role fairly recently. I think it will become increasingly important, because the day one rights are going to kick in even within that initial period of employment. It's highly likely that you're going to have to follow some procedure that you don't necessarily have to do now, and therefore managers appreciating that that's the case will obviously make sense. And that change of mindsets bullet point, the final one on that slide, is really about the fact that some employers, not all, but some employers, I think, have fallen into a bit of a trap around thinking, oh, well, it doesn't really matter if this person's performing or whether they're working out. We can let it run for quite some time because we can get rid of them, almost for any reason within the first 2 years. And obviously that will change significantly. And employers who are thinking that way are going to have trouble, essentially, because if a manager's not on top of this stuff and hasn't changed their mindset away from that 2-year mark, then it's going to increase risk around claims from fair dismissal in particular, and things are not going to work out so well. So getting that message out early, even though this is likely to come into force next year, so that's the upside. We do have time to prepare for it, but certainly we are encouraging clients to think about those things. But also, of course, the thrust of this session, which is if you hire people in a way that increases the chances that they are good, and you manage them when they're with you, and you manage them well, and you take early decisions as to whether they're doing well enough to stay with you, then you're going to be well prepared for these changes coming in. And of course, it's essentially good practice already, and will help with all of the things that we're going to talk about. So that's an introduction to why we're talking about what we're talking about and what's coming with regards to the unfair dismissal day one rights. As I say, it's worth keeping in touch with us in terms of following us on LinkedIn, being connected there, and signing up to our mailing list on newsletter to make sure that you get those updates when we know more, when the government tells us more. And on that note, I'm going to hand over to James to talk about recruitment.
Yes, thanks, Nick. I now control the slides, always the tricky handover. Morning, everyone. So yeah, we're going to kind of work through in a logical cycle of how you might employ someone, and then we're going to, as we do sort of doom-mongering lawyers, talk about what can go wrong after that. So we'll start with recruitment, and a lot of these points probably seem quite obvious, so bear with me on that. But I think sometimes it's easy to forget the basics, and getting those right will solve a lot of problems. So the first point on the slide, incredibly obvious, identify what the vacancy is. But leads nicely into the second point in terms of job descriptions and person specifications. There's always a danger that you hire someone because they're good at what they do or they present well at interview. But is that what you actually need them to do? So if you're being really thorough and getting a good job description and a good person specification, you can then target your recruitment to make sure that the role is clear and that the person you are recruiting has the relevant skills for the role. And that should help to reduce issues down the line. These days, there's also lots of other things to consider when you're identifying the vacancy, such as, is it full-time, part-time? Could it be done by a job share? Could it be done remotely, hybrid? All those new things that are now becoming more and more prevalent. And even if it's not advertised, you're likely to be asked about. So it's worth having a think about those things straight away, so you know where you're going in that regard. A document that I'm going to refer to throughout this talk, which if you haven't looked at recently is worth a read. It's the Equality and Human Rights Commission's code. I think Matt's going to pop a link in the chat. That's got all kinds of useful information on recruitment, but also reasonable adjustments, which we're going to talk about later. So if you've not had a look at that document recently, it's still very good and appropriate, and is something that an employment tribunal would consider if they were referred to it by one or other of the parties. So that's always worth bearing in mind. And that code has some useful tips on job descriptions. Unsurprisingly, they suggest to make it appropriate, but how do they suggest doing that? Well, they suggest focusing on outcomes and try and avoid being too specific with things like working patterns. That's perhaps because one of the focuses of the code, clue was in the company that, or the organization that's created it, the Equality and Human Rights Commission, is avoiding discrimination. And so a lot of their tips will keep you on the safer side if you were to follow them. And with that in mind, how do we be mindful of avoiding discrimination? Well, there's a few different aspects as to where you need to be careful. One is advertising, or larger employers, or where practicable, the code recommends using a range of media, so that you're getting a good range of candidates, not all those who might be from similar backgrounds or get their information from similar sources. One good thing that I must admit I hadn't thought of, being not something I particularly do on a day-to-day basis, advertise roles, was referencing diversity and inclusion. It's explained that if you do that in your advert, you're much more likely to get a wider range of candidates, because the candidates from perhaps underrepresented groups will feel more comfortable and see that as a real positive for the organisation they're applying for. I've suggested using a standardized approach. Well, what do I mean by that? Well, one of the things that can come up is different decisions about how you might advertise for a role. For example, do you recruit externally or internally? There might be certain scenarios where you ought to be doing internal recruitment, for example, in a redundancy situation, but often it can be tempting to only consider internal candidates. But the converse, or the negative to that, can be that then it reduces the chance of diversity, and perhaps also you're going to potentially get someone who's not so suited to the role, because you've clearly, if you're only looking internally, you've got a narrow selection pool versus the wider world. So have that discussion internally, or consider whether it's going to be internal, external, both, and why. And as it wouldn't be one of our seminars if we didn't say the word paper trail or audit trail. And when you're going through the recruitment process, even the planning, it's good to keep an audit trail of that in case someone was to challenge it later. Similarly, in terms of the diversity angle, it can be very tempting to recruit based on recommendations of other people. And whilst that can be good, obviously there might be a known quantity. You've got sort of dangers from that linked to the things I've been alluding to. They might be recommended, but do they actually fit the person spec? Do they actually fit the job spec? Do they have the skills? And by just going with people that your existing staff are recommending, are you potentially stunting diversity? Because the chances are people who know your existing staff probably are going to share similar characteristics. Not always, but sort of statistically it's more likely. So if you're going down that path, consider why or whether you should be before you do it. Occupational requirements, it wouldn't be a discrimination comment on recruitment if I didn't mention that there is the exception in the Equality Act where you want to recruit someone who holds a particular protected characteristic because it is an occupational requirement for the role. The example I always roll out is if you're looking to create an incredibly authentic Italian restaurant, you might want to try and have someone who is Italian to be front of house, for example, and you can potentially justify that as an occupational requirement. Reasonable adjustments, the code is very good at giving some examples for this, but you might want to consider, especially if you're a larger employer, making your job adverts or similar available in multiple formats, large font or braille, or at least being obtainable upon request. So moving logically along, once you've got your job specs, person specs, and your applications are all coming in, what do you do next? Well, usually you would shortlist. I'd always suggest, if at all possible, having more than one person do this to avoid any sort of subjective bias that that person might have, whether they realize it or not. And having two different people looking at the same things independently is probably going to give you a better overall picture as to who the candidates are, if you can. Ideally, use clear and objective criteria for assessing which applicants to shortlist for interview. A good analogy would be a redundancy process where you might set criteria and mark the candidates against that. Why do you do that? Well, because the case law in the tribunal says you need to adopt a fair basis for selection. And if you do and you document that, you can defend unfair dismissal claims. Whilst the same problem isn't going to arise in interviewing, if someone challenges your recruitment decision and, for example, says it's discriminatory, if you've got clear and objective criteria and you've ranked the people or applied it to decide who to shortlist and not, it's going to be much harder for them to say, I didn't get shortlisted because of a specific characteristic. Another thing that can potentially be done to sort of avoid discrimination style arguments when shortlisting is try and do it name blind if it's possible. Sometimes not practicable, but if you're just looking at the contents of the form and not the names, it avoids any suggestion of bias in that regard. Interviews, as you'd expect, similar comments there. Try and keep the interviews consistent, so all the candidates are asked the same thing, so you can fairly compare them. And the EHRC guide or code does have good suggestions as to what you should and shouldn't do, keeping the questions linked to the application, the job description and the person spec, and not veering off onto other topics is a way to stay safe. Something I'd certainly recommend is don't set your managers up to fail. So if they're going to be put in to interview situations and that maybe isn't something they're familiar with because they're just doing it for a specific team, then make sure they've had the relevant training, particularly on equality and diversity. You'd be surprised of some of the interview stories that I've had over the years. It was probably about 5 or 6 years ago where I had a case where in the course of the interview, the candidate who wasn't really approaching the statutory retirement age, but because he'd stopped working for a couple of years, one of the interviewers made an insinuation that he not have enough money to retire. And then it won't shock you to hear that when he didn't get the job, he put in an age discrimination claim, which was rather awkward because although there were valid reasons on the shortlisting and the interviewing why he didn't get the role, the feeling he certainly had, and with some merit, is that age might have had something to do with it because it came up and it wasn't relevant. So it's easy just a throwaway comment to get into a bit of a tangle with the tribunal that you don't want. Tests, they're quite common these days, written tests, psychometric tests. Whether you use them is up to you. All I'd say is consider whether they are necessary or appropriate, and be mindful of potentially disabled candidates. Are they able to be on a level playing field when they're doing those tests? Are there any adjustments they might need, additional time, different formats? I'll come back to reasonable adjustment more generally, and as you'll see when I talk about that, there's no one size fits all model, but written tests and psychometric tests are a clear area where it could lead to issues arising. So just be mindful of that. And then finally, feedback. What to do when unsuccessful candidates, usually, I suppose successful candidates might ask for feedback, but it's usually unsuccessful candidates. What to do when they ask for feedback. Generally, my suggestion would be the good practice would be to give it, because that's going to likely reduce ill feeling if you don't give it. And also it shows that you've got nothing to hide if you're confident that your process was robust. Why would you not give feedback? And with that in mind, you should link the feedback to the application itself. So stick to objective factors, why they didn't get the role. And I'm sure most people on this call would do this because it's a matter of good common sense, but try to do so in the most sensitive way you can. clearly you want to give honest feedback, but you also want to give feedback that's not going to lead to the person being upset or looking to pursue it further. So it can be quite tricky, but to try and strike that balance between sort of honesty and objectivity with sensitivity. Easier said than done, I know. So we're pressing on through. It's a lot quicker in seminar world recruitment than in practice, I know. We've already got to the point of making the offer. Few little safeguards that you can build into this process, time permitting. So a lot of the time offers are made subject to conditions. That's a good idea. Usually that's put in the offer letter. I've listed some examples of the types of conditions that might be relevant for certain jobs, but clearly there might be others, or some of these might not be relevant. Always a good idea to follow up on things like references, because the next point I'm just going to flick to the next slide is when it goes wrong, often you might want to withdraw the offer. Timing can be quite critical with this. So if you've made an offer and it hasn't been accepted, then it's easy. You can withdraw the offer and just communicate that withdrawal to the candidate. No problem there. What if you've made the offer and they've accepted it, but then you find out the conditions aren't met? Well, if the offer was made subject to the conditions, then usually you can still withdraw the offer on the basis that they didn't meet the conditions, even if they'd accepted it. The big caveat to that would be, though, where there is actually a contract of employment already in place. What do I mean by that? Well, if you've said the offer is subject to satisfactory references and you get unsatisfactory references, you won't be able to say that there's no contract of employment if they've been working for 2 weeks and you've been paying them. If that hasn't happened and it's before they've started, then you can say that the offer conditions weren't met, so it's withdrawn. But if they've been working for you 2 weeks, then regardless of the conditions, they are working for you. So in that scenario, or in other scenarios where the offer's been accepted and there is a contract of employment, you can't technically withdraw the offer. So if you wanted to part ways, you'd have to terminate the contract. And usually the way to do that, either before the employment started, or if it has already started, is just by serving notice. And most times, most contracts these days, or they might not, the notice period will be shorter, at least initially, because there'll be a probationary period that will probably apply. So you can give notice before the contract starts. I've frequently advised on that. So that's something to bear in mind with making offers subject to conditions. The beginning of employment, moving the journey along. Nick's already alluded to the initial period of employment. Is it 6 months? Is it 9 months? Who knows? But keeps flipping between the two. I think it's a good bet to be one or the other. But anyway, the thing we definitely do know is that it's worth being ready for that new world, because whatever it is, it's less than 2 years. So you'll certainly be much quicker into the scenario where people can claim unfair dismissal. And also, who knows how light a touch the light touch is. So how different it would be in the initial period than after is unclear, but clearly anything you're doing after that would be fair before. So that's useful, and it might, depending how light the light touch is, just be easier to follow the same process all along. I mean, I'm not suggesting we need to do that, because we don't know what the legislation is, but if we're prepared either way, that can't be a bad thing. Induction, often overlooked. People are busy, I know, but induction, a lot of good things can happen, and perhaps the most useful thing is training. And I had 2 specific sort of training topics that to me seem to be critical, especially in the context of the new world of initial periods of employment. Firstly, is training on the actual role itself. If you are going to be terminating in the initial period of employment, unless it's a very, very light touch, or even just generally, it's going to be better if you can show that the person was provided with any necessary training to do their role right at the beginning. So ticking that box and making sure everyone's got that training in is going to help you. The other is diversity and inclusion. Getting that done from as soon as possible is a good idea for a number of reasons in the event of a claim. And one of the things that comes up all the time in tribunals in various different contexts, whether it's a capability type scenario where performance is being discussed, or whether it's a discrimination type scenario where somebody is alleging discrimination. It's always useful to be able to evidence that people have undertaken training. So the audit trail on training is really useful, and that's not just new recruits, it's managers, it's everyone. So don't forget the audit trail on training. Doing the training is really good, but proving that you've done the training is even better. Disabilities, as I said, we're going to come in quite a bit of detail to disabilities later on, but in terms of the beginning of the employment, you can save yourself a lot of pain down the line by bottoming out issues. So although you can't base recruitment decisions on disabilities, once you've offered someone a job, you can then start asking questions about any type of adjustments. So if there are physical things that you need to have in place, like equipment, software, etc., try and get those ready before they even start, if at all possible, or at the very least bottom it out as part of an induction process. And this can help you down the line, because if you're actively engaging and communicating with new starters as to what they may or may not need in relation to any disabilities to do their role, if things go wrong down the line, then you should have sort of preempted any discussion of, oh, well, the reason it's going wrong is because I didn't have these adjustments, or I needed this assistance, or if you've bottomed it out at the start, it should make things much easier. And if someone does bring it up later, you could say, well, hold on a second, we talked about that. Why didn't you mention it earlier? And it could be questions of whether or not it's what they're saying is genuine, or whether it was wrong of them to withhold it. And you'll certainly be in a better position if you can show that this has all been boxed off as far as you reasonably can, as soon as you can. Probationary periods, I think that's one of the most irritating features of the new world, is that we're going to use probationary periods and initial period of employment, and the press is already talking about statutory probationary periods, which is the initial period of employment, and I suspect there's going to be two parallel concepts that everyone muddles up. So by probationary periods, what I mean now is the thing in the contract that most people have where it says the first X amount of time is a probationary period where your performance and suitability for the role will be monitored. At present, with the 2-year rule, one of the most important reasons we have that is that just the notice period is different. So often it'll say in the probationary period, either party can terminate, or one party can terminate on 1 week's notice, and thereafter it increases often to, say, a month, rising with statutory. So potentially it's a big deal if you terminate, whether you're in the probationary period or not, because it could be the difference between a month's pay and a week's pay. Other things can also be triggered by probation periods. Contracts often say you'll receive certain benefits, I don't know, health insurance, subject to satisfactory completion of your probationary period. So we need to know whether employees are in their probationary periods or not. Standardize the process. I know that's, I said that about 3 different times in 3 different contexts, but I don't shy away from that. It is a good idea. And by standardize, I mean have probationary review meetings for everybody who has a probationary period. If people are doing really well, still have the meeting, pass them, because if you're in a claim scenario, whether that's unfair dismissal or discrimination, if you can show you're treating everybody the same and everyone is being treated to the same criteria or objectives or standards, then it's going to make your position much better if you're trying to justify what you did and why. So it's not just where there's an issue. Extensions, often contracts say the probationary period will be 3 months, but this can be extended by up to 3 months in writing. Make sure we follow our own contracts. So if you arrange the probationary review right at the end of the 3 months and the person is sick for whatever reason, and then 3.5 months in you have the probationary meeting and you haven't extended it and you want to extend it, you might be in a situation where you try and extend it, but as a matter of contract, you simply haven't. Whilst that won't make any difference for the initial period of employment when that comes in, again, it might make a difference to the issue of probationary periods and notice periods that might apply. And if, as is often the case with probationary periods and contracts, you need to extend in writing, we need to make sure we keep the paper trail. finally, on this initial section, before I switch over back to Nick, tricky issues or thorny issues that commonly come up in recruitment. Lying applicants. Well, that can be either their actual application is untrue, but you find out and then you don't hire them. That's probably the perfect world. But more common is you find out down the line that things aren't true. I can think of some high profile examples. I won't mention them. But what do you do? I think sometimes everyone gets a bit excited if they find that someone's lied and think it's immediately and always grounds for immediate termination. It might be lots of factors to consider if you find out that someone has lied. I mean, usually a disciplinary procedure will have dishonesty listed as a potential act of gross misconduct. So that's a potential avenue to go down. But how relevant is it to the job? How big is the lie? Is it a true lie or is it just misleading? It can be quite nuanced. And another important consideration is how long they've been employed, because if they're still in the first 2 years or in the future world, the light touch period, you might be safer dismissing than not. And similar risk analysis might apply on whether or not you terminate with immediate effect or whether you just say, we can't trust you anymore, we're going to pay you notice, but there we are. That again might be linked to whether they've got any statutory rights and what the light touch is. Former employers applying to come back. That's always an interesting one. I do get that call ever so often, ever so occasionally. Such and such has applied back. They would perhaps meet the person's spec, but we don't want them back for X, Y, and Z reasons. The good thing is, if it's just specific to the person, that's not a protected characteristic in that it's not their age, race, or any one of those things. It's something specific about them. It's because they did something that you perhaps didn't like, or their work wasn't of a certain standard, or they upset people. So generally speaking, you wouldn't be prohibited from saying, we don't want you to come back because of something you did before. Your main risk, as I say, is discrimination. And the only other sort of risk that I should flag, although it doesn't come up very often, is there is specific laws on blacklisting to do with trade union activities. So if you were breaching the blacklisting legislation by not having someone back, you need to be careful on that. But very, very rarely does that apply unless you are in a unionized workforce. I'm pleased to say I've never come across an employer who actually had a blacklist, or at least admitted it to me. So there we go. So I'll hand back to Nick for managing.
Thanks, James. So here we go. You've got a question there, James, as well. So managing better. So we've recruited people. We're hoping for the best. We're hoping that they're great and they're going to do a fantastic job for us. But we are actually going to have to manage them while they're with us. And it might be that they don't perform quite at the level that we'd hoped. And lots of what James and I help with is managing those people out of the organization. And we often have to remind ourselves that actually performance management is not just about that. And sometimes managers need reminding that it's not just about that, but that actually it's designed to try and help someone improve and actually be able to do the job that they're employed to do at the level that we would like. But as I say, we often end up looking at the worst case scenario, the end process where we're having to let that person go if performance doesn't improve. And therefore, we're going to focus on some of the risks around that. And what we might do in terms of taking steps to managing performance well, in the hope that it improves, but if it doesn't, that we are moving people out of the organization safely and minimizing risk. And of course, the key there is that this will become more important because day one rights will mean that even with the light touch process, there will be some sort of process that we're going to have to follow in order to move these people through. So the key claim, unsurprisingly, we've talked about it several times already, would be unfair dismissal. And just a brief recap in terms of the kinds of things that we need to be thinking about when it comes to that kind of a claim, or in fact what a tribunal will be thinking about should we be in the tribunal facing a claim and defending it. What they will need to assess is whether there was a potentially fair reason for dismissal. And there are a number of those that you'll have heard of, things like conduct, redundancy, and so on. The key one really when it comes to performance management is capability. So that's the fair reason that we're highly likely to be relying on, and we'll talk about where actually that overlaps with misconduct sometimes. But for the purposes of this, let's stick with capability. And that's basically where the person doesn't have the skills or the aptitude to perform the role at the required level. Now, actually, capability also covers health issues. And that's relevant to, I think, the section later that James will be talking about in terms of reasonable adjustments and disabilities. But it sometimes, again, gets a bit muddled in terms of the fact that it covers both performance and also health and the impact that has on the person's ability to do the job. So that's worth keeping in mind. We're also then looking at needing a fair procedure, and we're going to look at that in a bit more detail as we go through in terms of what that would involve. But many of you will be aware of some of the issues there. We referenced the ACAS code on the slide there because that code, when it comes to disciplinaries and grievances, is relevant to dismissals. That said, it doesn't necessarily cover performance processes in loads and loads of details over and above the case law that covers this area, which informs a lot of the decisions that we need to make in terms of performance managing well. It tends to come from cases that have decided these issues. And usually your internal procedures, the final point there, will reflect that body of case law that's kind of built up as to how tribunals expect employers to manage performance well. So that's where lots of that comes from. That said, there are certain basics in the ACAS code that, when it comes to dismissals, that are clearly important. The person, knowing what they're going to be facing when they attend a dismissal meeting, the right to appeal, the right to be accompanied, all those good things that you'll no doubt be familiar with will apply when it comes to a performance dismissal as well. So procedure-wise, we're going to look at some key points here. Now, James has covered some of this actually when it comes to his section on recruitment and that kind of final part of the recruitment process. There is some overlap. And he emphasized that a probationary period is really useful in terms of setting those consistent standards. And clearly, the person understanding what they're supposed to achieve in their role and what will be required of them during that initial period is really important. And setting that out clearly and training them, as James said, is something that a tribunal will expect to see. But they'll also expect to see other performance procedures in place, I guess, and appraisals is one of those. And again, appraisals over the years have had quite a bad rap. I think it was certainly trendy to do away with the annual appraisal for a while. But when it comes to this kind of thing, they've always seemed to me to be quite a good marker where at least once a year, and the theory goes that it should be happening more regularly than this, but at least once a year, a manager is sitting down with the person and talking about how they're doing. And just out of interest, if people are able to access the chat, it'd be really interesting to see who still runs an annual appraisal. I don't think you should be ashamed of running an annual appraisal. I actually think they're a good thing. That said, people may have other ways that they're managing performance, but it'd be really interesting to see how many people are actually still running an annual appraisal. And you certainly get a thumbs up from me from that perspective. There we go. We do them every 6 months like that. So yeah, it's great to share some of that as well and get some feedback for everybody that's on the call. So audit trail. James has already emphasized the importance of that, particularly with performance issues. Being clear on what's been expected, that's been communicated to the employee, and that we're then tracking performance is super important. And as the slide says there, dealing with problems when they come up. So yes, not waiting till the annual appraisal, in a year's time. And the new world, as we've talked about, is going to do away with, that being okay for sure, because you're going to have to make decisions well in advance of a year. But of course, people, managers in particular, engaging with employees when things are not going well, is going to be more important than ever in terms of this stuff, and then capturing that in some way, be it an email record or some sort of audit trail as to the fact that the person has been told that they're not doing something quite right, and that it's been addressed. So that's going to be super important. In terms of how a tribunal will then look at things, and when they are deciding whether a fair process has been followed, they're effectively looking at something similar to the test for misconduct. So does the employer believe on reasonable grounds that the person is incapable or incompetent, incapable of doing their role? And clearly you then need to be able to evidence the fact that that was the case and that you had that belief as the employer. And again, that's not complicated to do in reality. That's about investigating the issue. And if a manager's doing the job that they should be doing in terms of managing performance, that audit trail will be created as a result of that. So actually investigating what the issue is, talking to the employee about why they're not doing what they're supposed to be doing or achieving what they're supposed to be achieving, making them aware of that is the key starting point. But then supporting them to improve is one of the key aspects of this, and even potentially running additional training for them, because James talked about training at the outset, them understanding what they've what the role involves. But if they're struggling in an area, emphasizing that support either from a manager or other colleagues and some training on those issues will be a key part of this. Reviewing progress against those objectives and making those objectives measurable, reasonable. So not setting the individual up to fail. If that comes across as very obvious, then it's going to be an unfair process and therefore likely an unfair dismissal if we get to that point. But clearly a review process against those objectives to see how the person's doing, again, engaging with them on that is going to be really important. And then if we do get to a dismissal, as I mentioned earlier, allowing them the right of appeal to challenge that again is also going to be key in terms of the fairness of that process. Then just some sort of tricky issues, I suppose, when it comes to the performance side of things, and alternatives, I suppose, as well. We're gonna look at. So often, we'll get an inquiry around poor performance, and we'll usually say, okay, so how long has the person been underperforming? And often clients will say, well, about 3 years now, and we'll say, so have we run a process so far? And the answer will be, oh, no, we haven't really mentioned any of it to them. Now, can we dismiss them? And of course, you'll have picked up from the session so far that that's going to be difficult to do, because lots of those things that we've suggested are necessary to fairly dismiss somebody, are highly unlikely to be done. And in that scenario, to dismiss for performance, we're very likely to have to be starting a formal performance improvement process at that stage, and that can take some time, and that is usually months in terms of the timescale, which often does create frustration with managers where somebody's been underperforming. So sometimes the query will be, well, it's a very, very serious underperformance, can't we just dismiss anyway without having given some warnings as part of that process? And usually the process will involve here's a first warning, second warning, final warning, whatever it might be, in terms of your internal procedures on that kind of thing. But actually something is so serious that the employer wants to let the person go immediately. Now, usually that's not possible. It would be a high risk dismissal in that circumstance if performance hasn't been addressed to that point. The limited exception to that is where that incident, that underperformance, is so serious that it's effectively gross negligence. So somebody almost has deliberately, not performed the duty that they should do. Now, query whether there's a significant overlap there with misconduct anyway, because if it's willful in terms of their actions, as opposed to just negligent, then it might well be that you're looking at a misconduct issue and not a capability issue anyway. And of course, that would then follow a misconduct process in terms of investigating the issue, taking a view on what evidence there is there, and potentially looking at a misconduct or gross misconduct dismissal. And for that reason, if actually there was evidence to suggest that the person had deliberately done the thing wrong that they were accused of. So it is possible in very limited and very serious circumstances. The other thing that crops up and is often tricky and often a frustration for employers is that actually someone's performance improves, and if it's maintained as at an improved level, then happy days. We, remove the performance improvement plan from that person, and it's all good, and they're our star employee now. But sometimes that's not the way it works, and sometimes performance improves just in time to clear the length of the warning that might be, for example, 6 months, and then performance drops off again. And we're back to sort of square one, or at least it feels like we are, because that's, the warning is expired and we're still only back at the beginning of the process, but we have the frustration of the person still not performing. There's a couple of ways of approaching this. Again, almost linked to my previous point. If there was, for example, evidence that the person was deliberately taking their foot off the gas, shall we say, at the end of each warning period, it might be possible to suggest that that's a misconduct issue. The tricky thing with that is likely to be evidencing that that's the case, and arguing that, okay, well, you managed to perform for 6 months until almost the day that your warning expired, and now you're terrible again. Doesn't really make sense to us. We think that you're sort of playing the system a little bit here and looking at a misconduct issue. I think probably the more realistic outcome is that we look or consider extending the length of the warning period, effectively the review period in that sense, so that actually the person has to perform for a longer period of time in line with that warning, as opposed to it being shorter and it dropping off and us having to start all over again, as it were. So there's a couple of ways of dealing with that issue, which sometimes happens. Hopefully performance obviously hits the required level and stays there, but it doesn't always, and hopefully that's helpful in terms of managing some of those issues. The other, I suppose, elephant in the room to a certain extent are settlement agreements in these scenarios, and often people are wondering, can we just offer this person a settlement agreement? We're not prepared to go through a lengthy performance improvement process. We just want them gone. And I guess the way that we approach that is, first of all, we're not going to say to any client, you can't dismiss somebody in any circumstances. We'll advise as to the risk of doing that. And even if a performance process hasn't been followed, you might decide that commercially it makes sense to dismiss that person because they need to be out of the organization. And you understand the risk as we've advised you as to that, and you take that decision. So certainly we're not saying you must absolutely follow this process in all circumstances. But clearly, an unfair dismissal claim against you is not a brilliant idea either. And therefore, often the discussion is, well, we're going to kick off a performance improvement process, but actually that's to indicate to the person that they're not performing at the required level. But in reality, we're not, as the employer, prepared to take them through all of that time and effort and process. And often, unsurprisingly, managers are very keen to shortcut that, get somebody new in who's, a higher performer, and exit the person more quickly. Now, one option there in that scenario is something called a protected conversation or pre-termination negotiation, which we actually ran a separate webinar on. And I have a link to that, which I've popped in the chat, in terms of doing protected conversations well. There are certain drawbacks to that process, and we talk about the difference between without prejudice and protected conversation, because in most circumstances, without prejudice, as a rule that allows you to have discussions about somebody leaving, is unlikely to cover you in the scenario of a performance process here. It's usually post dismissal that without prejudice will be more relevant. So protected conversation is the appropriate route, and do check out that webinar for managing those well. But I think, again, one of the key issues that you have in this sort of scenario where we're offering a protected conversation or a settlement agreement in a performance situation is that if the individual doesn't agree that they're underperforming, or doesn't believe that you will follow through on the process and dismiss them, then they may not be prepared to take an offer to leave as part of a protected conversation. And you've had that conversation indicating that you would like them to leave, because however correctly we present that to them, there's still a risk that they take it to mean that you definitely want rid of them. And if they then decline the offer, you're still stuck with the employee and having to manage them through a performance process, or simply dismissing them on the other side of that, which can make things difficult too. So it's certainly worth balancing the risk, and I think understanding the timing of when you might offer an alternative to a performance process via a settlement agreement protected conversation, and often taking advice as to the best way of doing that. But there's no doubt it would be wrong of us to say that every employer always follows the full performance improvement process when dealing with these issues, because it's simply not the case. Often employers are not prepared to do that, and will look at other options too. So yeah, that's the headline on the elephant in the room to a certain extent. I'm going to hand over to James, and he's going to talk about one of the key areas around performance management and disability in particular.
Thanks, Dick. Yeah, I sort of lagged earlier that I was going to talk about disability discrimination, or discrimination more generally, but primarily disability, because although Nick was right to say managing performance to avoid unfair dismissal is perhaps going to be more important in the new world where the initial period of employment will be shorter than 2 years, there remains the bit before that when you're in the light touch, whatever that means. And more generally, there's certain advantages of discrimination claims, such as you can get more compensation potentially by succeeding with one. And because the legal tests of what you have to establish are different, it might be that that's actually the appropriate claim anyway. It's not a question of unfairness, it's a question of discrimination. So useful to talk about this now, and the other good thing is it's sort of immediately relevant. We're not speculating about law that doesn't exist and has been changing and ever growing by the looks of the recent releases from the government on the Employment Rights Bill. So the first point to make is, although I'm going to focus the majority of this section on disability discrimination, in a performance context, you could bring a claim regarding any of the protected characteristics, just applying the usual direct discrimination test that I have been treated less favorably because of insert protected characteristic. And the way you avoid that is just by consistency of treatment. If everybody is being treated to the same standards of performance and the same policies and procedures are being applied, it's going to be very difficult for someone to say, well, I only got this warning or put on a performance improvement plan because of my insert applicable characteristic, ignoring disability. The reason that disability is so much trickier is because it's not usually the case that someone would treat someone less favorably because of the disability. It's the impact of the disability on them. And that's where the two claims I've highlighted at the bottom of the slide come in, because they are the two from my experience that are most common in a scenario relating to performance management, whether that's dismissal or even just the very, very early stages of indicating to an employee that you think there's a concern and perhaps starting an informal process. That can trigger these types of claims. So we're going to go into a bit of detail about what I mean, what the claims are, and then how we might avoid them. So a common claim, as I say, is discrimination arising from disability. So we've set out, just for back to basics, what are the elements of this claim, or what the person bringing the claimant would have to prove is that they've been treated unfairly, or sorry, unfavorably, because of something arising from their disability. So the I'm getting confused. The treatment, the unfavorable treatment, is usually the initiation of the performance management or the performance warning or the dismissal. and the something arising that they receive that unfavorable treatment for is the poor performance. So what they need to do as the claimant is link the poor performance and the something arising to the disability. So essentially, I can't meet the required level because my disability infects me in this way, or I can't meet the required timescale. So it's a causative link. So the link needs to be between the something arising and the unfavorable treatment. And that can easily happen in the context of performance with disabilities, where the disabilities might affect the person's ability to do the role in certain ways. Now, there is a defense for the employer. So it's not an absolute winner if the employee can establish the unfavorable treatment because of the something arising from disability. The employer does have the defense that the treatment was justified as a proportionate means of achieving a legitimate aim. As with such defense, the legitimate aim is usually the easy bit. In this type of context, the legitimate aim would be ensuring an adequate standard of performance or maintaining appropriate performance management. The much, much trickier bit is establishing that the treatment that was then doled out in pursuance of that legitimate aim was proportionate. So it went no further than was necessary. And as you'd imagine, given that the nature of this law is that concessions are going to need to be made for disabled workers. The other key factor, and this links back to the beginning when we were talking about recruitment and induction, is knowledge. So for an employer to be liable for discrimination arising from disability, they have to have knowledge of the disability. But that will include a situation where the employer should be reasonably expected to know of the person's disability. So have you made appropriate inquiries? And that's not just initially, but if poor performance arises, that's a pertinent point to sort of query it. I know I've flagged earlier that you want to bottom out these things as early as you can, but if you haven't and the person then tells you, or something is suggestive of a possible disability and you don't ask the question, you can still be in a situation where a tribunal will say, well, we accept you didn't know, but if you'd have made appropriate inquiries or asked questions and or got advice from a medical professional, then you can be held to have known, even if you didn't know. Concept usually referred to as constructive knowledge. Once you do know, usually the trickiest part when managing this type of situation is an employee might say to you, I'm having problems meeting this objective in the role, or I'm having problems doing this because of my disability. And as an employer, you probably don't know whether that's true or not, because it might be a condition you don't have any particular knowledge in, all kinds of disabilities, and every employee is different. So even if you're very knowledgeable about, say, dyslexia, it doesn't necessarily, and I don't profess to be an expert in this, so don't put into the chat that's not correct, because you're probably right. But the general point, it probably may not work so well with that particular issue, but is disabilities affect people differently. So it's not a one-size-fits-all model. So getting expert evidence on this particular person, perhaps by speaking to occupational health, is you can then better understand whether or not the issues actually do arise from the disability or not. And that has other advantages, which we'll come to later. And incredibly obvious point, fourth bullet point, but one worth flagging. Speaking to the employee, I flagged out bottoming out issues at the start of employment so they don't creep up when you start performance managing. That's the ideal scenario, but it's never too late. And do maintain the audit trail, because if we're saying we only found out about it then that's fine, but let's try and document that in case we do end up in the employment tribunal. Reasonable adjustments, that's the other common area. Worth a quick reminder on the law, because from my perspective, when I do a lot of disability discrimination claims in the tribunal, and it's an area where claimants often present their claim in a way that doesn't really engage with the actual law. And the danger is that nobody really engages with the actual law, and the parties muddle around and create a bit of a tangle. So what is the law? Well, The duty to make reasonable adjustments only arises in certain scenarios. The first one's the most obvious. The employee must be disabled. That doesn't present you making adjustments to people's roles because you want to, but the law on reasonable adjustments isn't engaged unless the employee is disabled. And then there has to be a PCP, that dreaded phrase, a provision, criterion, or practice, or a physical feature of premises, for example, that puts the disabled worker at a substantial disadvantage in comparison to persons who are not disabled. There is a third scenario to do with auxiliary aids, which I won't talk about because it's a bit more specific and is much less common in practice. So once that duty is triggered, what does the employer have to do? It's the bit in the brackets. They have to take such steps that are reasonable to avoid the disadvantage. So I like to look at it as problem solving. You've got to work out what the problem is, work out what you could do to solve the problem, and work out whether the things you could do are reasonable. So how do you work out whether it's reasonable if you've worked out what you can do to solve the problem? Well, there's no one factor fits all or one size fits all test. You just have to weigh it up, and the Equality Human Rights Commission code that I flagged up earlier has some useful and much more detailed guidance than I'm going to rattle off in a couple of minutes here. But the factors listed on the slide are a good one. I always think the first one is criminally overlooked. How effective would it actually be? Because, as I say, the idea of the adjustment is to alleviate the disadvantage. If it's unlikely to work and is going to cost a lot of money, then those two factors together might not make it reasonable. Whereas if it's dead cheap, might not work, then maybe it is more reasonable. If it's really likely to work and it's quite expensive, then that might make it reasonable. So the factors all intertwine. Is it practicable? So taking this back to the poor performance context, what is the dreaded phrase, the PCP, the provision, criteria, or practice? It's usually either the expected level of performance or the application of the disciplinary or capability procedure. I personally don't like to flag poor performance as a disciplinary matter, but some employers have a kind of joint procedure. That's why I've put them both there. Really, it is a capability issue, but you could have one procedure. So the first step applying my test on the previous slides is, does the PCP put the disabled worker at a substantial disadvantage? And you have to work out whether it does or it doesn't. How do you do that? Well, the first one, talking to the employee. The second one we've covered before, expert advice. You can see how the claims arising from disability and reasonable adjustments are very similar. In many cases are argued both ways. And helpfully, at least, the solutions discussing with the employee and expert advice are linked. So you can do both things together. I'm not suggesting you look at these two factors in isolation, but it's useful to have both angles in mind. Once you've done that, what's the next step? It's to consider what adjustments could be made to alleviate the disadvantage. So again, using the actual example of performance management, do you need to be adjusting the targets or objectives? Because perhaps the substantial disadvantage that the person has is they can't process work more quickly, so they need more time. Or perhaps they need additional support, whether that's time with their manager or a change to the way work is distributed or communicated so that they can fully grasp the tasks at hand. I mean, clearly it's going to be different for different people and different disabilities. Do they need specialist equipment? Do working arrangements need to be changed? Do they need to sit somewhere else? Very common one I get a lot of questions now is people are saying they want to work from home because it helps them with their disability. That may or may not be true, and that's why you need to work through this step-by-step process, work out what the substantial disadvantage is and whether it's caused by the disability, and then consider how you can adjust it. How you can alleviate that disadvantage with the adjustments. And then thirdly, once you've worked out what the problem is and what the potential adjustments are they reasonable? And if they are, you should do them. Where does it all go wrong? Well, From my experience, it usually goes wrong because the two parties become fixated on a certain position. It's often the case that an employee will declare that they want a specific reasonable adjustment immediately. And an employer can be skeptical that they actually need that because it might seem that they want it for other reasons, perhaps for convenience. For example, I need to work at home on a Friday afternoon because that'll help me finish off my weekly tasks. It wouldn't shock me if an employer took that to be you just want to work home on Fridays because you can start your weekend more conveniently for you. And the danger is, as I say, that you don't then follow the analysis I've gone through, and people become fixated and acrimony ensues. Keep an open mind. Maybe that is a reasonable adjustment, but you can work out whether it is or isn't by working out what the disadvantage is, looking at what potential adjustments are, working out whether it's reasonable before you get there. And communication is the key on that. Don't rule things out or in or get at loggerheads. Engage with the employee and try and be logical in making decisions. The third bullet point sort of linked to this, too much onus is often put on the employee as to what adjustments they want. Although I've just suggested the scenario where the employee actively advances their preferred adjustment, and perhaps it might or might not be appropriate, and you should look at it that way. The other is where the employer just says, well, we don't know what the solution is. You tell us. What do you want us to do? How can we solve the problem? And whilst that's a good idea to ask the employee for their feedback, the fact that they might not suggest anything doesn't suddenly insulate the employer from a claim for a failure to make reasonable adjustments, because the duty is on the employer to make reasonable adjustments. So if the person is at a substantial disadvantage, you need to be exploring what adjustments you could make. And if you decide there aren't any, just saying the employer didn't suggest anything might not be good enough. It might be that we engaged with occupational health and they said there wasn't anything we could do, but they might not have said that. And if you didn't ask them, it might be suggested that had you asked them, they would have said this. And the amount of times we see in tribunal that information comes away after the fact and the employee says, well, as it turns out, here's my medical evidence. And as you can see, had the employer engaged with this, we'd have established that these changes could have been made. And that could be quite problematic. So you don't want to get into that scenario. You want to take a positive step to engage with the duty and try and find out whether there is anything you can do, and then document why you did or didn't do it based on the reasons we've discussed here. And I'm going to hand back to Nick just to finish off with some cases, or I think maybe just one case.
Yeah, just one case, which I think helps illustrate what James has been talking about, and covers menopause, which again, I think we're seeing increasing tribunal claims covering that topic, and also employers grappling with how best to support during that time. So let's have a look at this one. It was a Direct Line case, so a claim by Mrs. Linsky against Direct Line, and she was working as a telesales consultant and had worked with the company for quite some time, and had been a good performer during that time. In 2019, so about 3 years into her employment, she started to suffer from menopause symptoms, and they impacted on her ability to do her role. So she described things like becoming more forgetful, brain fog, and some other behavioural changes as well. And as a result, Direct Line put her on a success plan, as they described it, trying to put a positive spin on a performance improvement plan there. And at the point that they reviewed it and she still hadn't improved, they issued her with a written warning. Partly as a result of the menopause symptoms, and partly as a result of the fact that Direct Line had issued her with that warning, her mental health deteriorated and she was signed off work. They then also withdrew sick pay as a result of that absence too. I think one of the things that they did do was also move her to a slightly different role. But again, she was, by the sounds of things, quite heavily performance managed within that role, and perhaps understandably wasn't performing at the level that she might have been expected to within that role as well. So in November 21, she raised a grievance suggesting that she'd been subjected to discrimination, and that grievance wasn't upheld by Direct Line, the employer. And then in May 22, she resigned and claimed constructive dismissal, suggesting that there'd been a failure to make reasonable adjustments and alleging that there was sex, age, and disability discrimination as a result of the menopause issues. So the tribunal looked at this, and I think it was just a first stage tribunal case, so it's not binding on other tribunals necessarily, but I think it is a useful illustration of how a tribunal might look at some of these issues when we're looking at performance that is complicated by an element of discrimination. First of all, the tribunal found that on this particular case, the symptoms of menopause met the definition of disability. And it's worth flagging that won't necessarily always be the case. And the tribunals look at menopause like any other disability. They look at the impact that it has on day-to-day activities, whether it's long-term and so on. And there have been cases so far both ways on that issue, as in some have been found to meet the definition of disability under the Equality Act, and some haven't. But on this occasion, they found that it did. And eventually, Direct Line conceded that was the case. Now, they were heavily criticised for maintaining a position where they were disputing disability despite the medical evidence that was available to confirm the impact that those menopause symptoms were having. And in fact, I think there may have even been aggravated damages awarded at the end as a result of that. The tribunal upheld her claims for discrimination arising from disability and failure to make reasonable adjustments, which is the stuff that James was just talking about, but dismissed the constructive dismissal and other discrimination claims. What they highlighted, though, were a couple of things that James talked about. The performance review outcome, a lack of pay rise linked to that, was a key factor in their analysis, and they decided that effectively it was discriminatory for them to have run the performance process in the way that they had. They almost went as far as to say that she should have been taken off the performance improvement success plan, as they described it, altogether, and that they should have taken account of the fact that she was suffering with those symptoms and adjusted things in a way that took account of those things. The other criticism that was made was that they hadn't taken occupational health advice early enough in the process, and that should have happened, which again, I've posted a link to the kind of managing sickness absence webinar that we've done before. You'll hear us regularly talking about the fact that we need good medical advice in these kind of complex situations where we can't understand, and even the individual can't understand exactly what's going on from a health perspective. And you will be criticised if you don't do that and understand the situation properly. We have recently developed a relationship with a good occupational health provider. If people are looking for contact details there, we'd be happy to let you know. Just drop me a message, either email or on LinkedIn. And I think the other thing that was really important was that it just was a prime example of an employer getting this spectacularly wrong. And in fact, a manager, as part of the fact pattern, the manager hadn't even been clear with the HR team that Mrs. Linsky had even mentioned to them that she was suffering with menopause symptoms, which clearly won't have helped the HR team get a good grip of the situation either and manage it well. So some sympathy for the HR and professionals involved on this occasion, but the manager didn't do them any favors by not being open and keeping that team informed properly as to what was actually going on. But essentially it was a catalogue of errors, I think, evidencing how not to do it. Much better to follow James's advice. So hopefully that's a useful example. In summary, we just wanted to highlight a couple of things just to finish. Clearly, getting recruitment right in the first place is going to be super important, and will save a number of headaches if you're increasing the chances that you're bringing good people into your organisation. And as we've said, as a result of the Employment Rights Bill introducing day one rights, it's going to be more and more important. In the same way, good performance management is going to become important too, and getting managers up to speed on how to do this well is going to be critical. We've seen a huge increase in the number of clients asking us to come and do training with their managers. Often employers are running management training schemes, programs for their people. And yeah, we've seen a huge increase in the number of sessions that we're running for employers, helping their managers get this stuff right. So real practical sessions, usually case study based, to help managers understand these things and do them better. So if that's of interest, again, do get in touch, and we can chat about how we can help with that. Because as you can probably pick up from the session, that kind of stuff's going to become more and more important as we go. And the other thing that's important clearly is following good procedures, processes, being careful of those complicating factors, discrimination, even whistleblowing, where people have said, you know, I'm raised concerns about things and now I'm being dismissed. We'll get around unfair dismissal issues or add to the risk that's involved. So following those procedures, being really, really clear on the reason for the dismissal, particularly with performance, you know, is going to be essential as we go. So we're due to finish at 11, so we've got 5 or 6 minutes left. If anybody does have any questions, feel free to pop them either in the chat, or it may be that you can unmute. I don't know whether that's actually possible as part of the call today, but if you're brave and you'd like to, James and I are very happy to pick up any questions that you might have. This is where I should have primed a question for James, isn't it? Just to keep him on his toes. We didn't do that. We're not as cruel as that. Okay, that's no problem. If you do think of them as we're just finishing off, you know, feel free to pop that in. As we said, it would be great to connect with you on LinkedIn and share some of these updates that are coming pretty much thick and fast. There's a number of consultation responses from the government on the Employment Rights Bill just this week, and we're doing our best to keep on top of them and post out any updates on that stuff too. So please do scan that QR code or find us on LinkedIn. It's a really useful way, whatever your view of LinkedIn is more generally. It's a great way of keeping up to date on some of that stuff. Even if you just have a look every now and again, there will be info there. Thank you for all the thank yous. So there's plenty of thanks coming into the chat. And if you're dropping off the call, we're really pleased that you could join us. There will be a recording of the webinar, Tracy, that will come out as part of the follow-up email after the session. So yeah, you'll get to see that. The links that I've posted as well, I think Matt put some in. If you go to our website in the Knowledge Hub, you can see all of our podcasts, all of our previous webinars as well. If you want to catch up on any of those topics, hopefully they're useful for everybody too. Okay, thanks again. Thanks for James and I. Have a good day. Enjoy the sunshine.